Hi, my name's Robert Fleming. I'm an attorney in private practice in Tucson, Arizona with the law firm of Fleming and Curdy. And I'm a certified elder law attorney by the National Elder Law Foundation and a longtime member of the National Academy of Elder Law Attorneys. I'm here to talk to you today about the basics of special needs trusts. We're not going to talk about how to administer special needs trusts, only a little bit about exactly how to prepare special needs trusts, but kind of a basic introduction to the notion of special needs trusts is what I'm hoping to accomplish today. First question that often comes up is, what's special about a special needs trust? Well, in a general way, special needs trusts are intended to protect the availability of public benefits to the trust beneficiary, and that makes it kind of complicated to keep your mind wrapped around it because special appears several times in many of those sentences, and beneficiary of both the public benefits program and a trust beneficiary. So keep in mind that what we're trying to do is create a trust. We'll set aside for the moment where the trust money is coming from. We're going to try to create a trust that would allow the beneficiary of that trust to remain eligible for public benefits. Now, it's possible that it's not public benefits, but private benefits or religious benefits or charitable benefits, but those are relatively rare occurrences, and the vast majority of special needs trusts are about maintaining eligibility for public benefits like Medicaid and supplemental security income, public housing, public nutritional support programs, and things like that. One of the things that further confuses this is that some practitioners and some states like to use the term supplemental benefits trust or supplemental needs trust and to intimate that it's a different thing from a special needs trust. And that would be fine if we could have some consistency about the use of the language, but there is no consistency. So special needs trusts and supplemental benefits trusts usually are pretty much the same terms. Unfortunately, some people who talk about supplemental benefits trusts use that term to describe third-party special needs trusts, and some use it to describe self-settled special needs trusts, and as we'll see in a minute, that's kind of the first key division between categories of trust. So it's not a helpful definition or a helpful term until we can get some sort of standardized use out of it. And as I say, some places they confuse it further by making it not supplemental benefits, but supplemental needs or supplemental care or some other term. So we're just going to talk about special needs trusts to describe both kinds of trusts, as we'll see in a minute. The key difference between special needs trusts and other kinds of trusts tends to be that the trustee of a special needs trust has broad discretion about whether to make any distribution of income or principal to or for the benefit of the beneficiary at all. So a lot of categories of trust that you might be familiar with and that have centuries of development in the law and in practice may require, for instance, all of the income of a trust to be distributed to the beneficiary. A special needs trust will not normally have such a provision. It may be that a given trust requires distribution for the benefit of the beneficiary and not necessarily to the beneficiary. A special needs trust will usually emphasize distributions for the benefit rather than to the individual beneficiary. A spendthrift trust may have a provision that says that the beneficiary cannot anticipate any future distributions and therefore can't sell the right to receive future distributions. And a special needs trust will almost always have spendthrift provisions as well, regardless of whether it's a self-settled or third-party special needs trust. But spendthrift provisions alone are not enough. We need to have additional language that makes it clear what kind of considerations the trustee is to take into consideration when deciding whether to make distributions of income or principal, and to specifically allow the trustee to make those distributions not just to the beneficiary but for the benefit. In other words, to pay vendors directly, pay providers directly rather than having to hand the money to the beneficiary to pay the providers. That's a key distinction between special needs trusts and other kinds of trusts. If a given trust, has very broad trustee discretion does not require distributions under any circumstances, doesn't have language about support and maintenance of the beneficiary, has a spendthrift provision, but never says anywhere in it the words special needs trust, it's very likely a special needs trust anyway. It's not the words that make it the trust, it's the distribution standards and limitations on the trustee's mandatory duties that make it a special needs trust. So what kinds of special needs trusts are there out there? Well, we can make lists of different names for special needs trusts, different sources of the money, but pretty much there are only two kinds of special needs trusts in the world that we have to deal with. The broad brush distinction is between self-settled and third-party special needs trusts. First, a third-party special needs trust. Third-party special needs trust is called that because the funding source is a third person, where the trustee is one person and the beneficiary is another. The money comes from a third person who might be the trustee, but ordinarily would not be. A third-party trust is the kind of trust that I might set up for my child who has a disability. I need to make my own estate planning decisions. I need to leave money to my child who has a disability, but I know that if I leave money to her outright, that will cause her to lose her public benefits, and she relies on those public benefits. And so I create a third-party special needs trust. The second kind of special needs trust, the second of the two major types of special needs trust, is the self-settled special needs trust. Typically, the most common self-settled special needs trust is one that arises from litigation. I have a disability, I sue someone over the cause of that disability. It was a medical malpractice or an automobile accident or whatever it was that caused my disability. I sue, I get a big settlement in the course of that litigation, and I realize that if I just take the proceeds of that litigation and put them in my bank account, I'm going to lose my SSI, I'm going to lose my Medicaid coverage for the extensive injuries that I have. It may be that the settlement money is insufficient to actually pay for my care because there were questions of whether the defendant was at fault or the defendant was inadequately insured, or for whatever reason, I'm not going to get enough money to take care of me for the rest of my life, and it's critically important that I maintain eligibility for public benefits. I would want to set up a self-settled special needs trust in order to maintain continuing eligibility for the public benefits and still receive some benefit from the settlement money itself. Now, it's important to note that a self-settled special needs trust doesn't necessarily require me as the person with the disability to sign the trust document. If the judge signs it on my behalf, or my guardian signs it, or my parents sign it, or even if it's set up by an insurance company, the defendant's insurance company, or my own, or my lawyer, or anyone else, but they're acting in my place, then it's a self-settled special needs trust, and it's going to have effects on my eligibility that we'll talk about in a minute. So the two basic kinds of special needs trusts, third-party special needs trusts and self-settled special needs trusts. I've often heard it said that the best metaphor is that third-party special needs trust is like a watermelon. It's big and juicy and satisfying, and there's nothing that tastes better on a hot summer day than a slice of watermelon. Yeah, it's got seeds, but you can spit the seeds out, and it's very, very gratifying to have a slice of watermelon. Whereas the third party, the self-settled special needs trust, is more like a pomegranate. You've got to peel that peel away very carefully. It's almost all seeds when you get it. Yeah, it's good, and in fact, we now know that pomegranates may be especially good for you, but it isn't like a watermelon. It's not as easy to work with. It's not as satisfying. It's not as effective, and that's very much an appropriate metaphor for the two kinds of special needs trusts, the third-party special needs trust watermelons and the self-settled pomegranate special needs trusts. Now, I've told you there are two basic kinds of special needs trusts. The third of the two basic kinds of special needs trusts is the sole benefit trust. The sole benefit trust is a little bit different animal. It looks a little bit like a hybrid of the other two. And so while there are really only two kinds of special needs trusts, the sole benefit trust is in some respects a third-party special needs trust to the beneficiary and a self-settled special needs trust to the settlor. More about sole benefit trusts in a moment. And there are actually two more kinds of special needs trusts that we're going to talk about: pooled trusts and so-called Miller trusts, or sometimes qualified income trusts. We'll talk in a little more detail about them in just a minute. The point is that of the two basic types, well, we can come up with 5, and if I really struggle at it, maybe 6 or 7 different kinds of special needs trusts that are all a little bit different. All right, let's talk about third-party special needs trusts first. When do you do a third-party special needs trust? What does it look like? Well, the dilemma that a parent of a child with a disability faces is, what are they going to do with the share of an inheritance that would otherwise go to that child? I just realized I've overgeneralized. There are lots of dilemmas that such a parent faces, but in the estate planning context, there's this one. What are they going to do? They might choose to disinherit the child, figure that the public benefit system will take care of them, and that their brothers and sisters will use their somewhat larger inheritance wisely and appropriately to help take care of the child with a disability. They might reasonably decide that the child with a disability has higher needs, and so they should leave most of their money or all of their money to that child and short the children who are getting along fine in life who don't have a disability. But the vast majority of parents, in my experience and in most practitioners' experience, decide that they want to treat the child with a disability more or less equally, more or less equivalent to the other children. And so they're going to leave them in an equal share of the estate, but realize that they can't do that without affecting their public benefits eligibility, and that the inheritance that they leave would then just be used to provide things that otherwise are available through the public system. And so they decide to create a third-party special needs trust if they've thought about it at all. Should that trust be revocable or irrevocable? It doesn't actually matter. It can be revocable by the parents who are setting up the trust. It can be irrevocable immediately. If it's irrevocable and someone else is the trustee and the parents have no residual interest in it, maybe they get it out of their estate. For estate tax purposes, for creditor purposes, those aren't the primary driving considerations for us here. The question we have is, what effect is it going to have on the eligibility? Well, if they make it revocable, it's not going to affect the eligibility. If they make it irrevocable and the child is a beneficiary and they put money in the trust, the distributions from the trust might affect the eligibility, but the fact of the trust itself will not. What kind of language needs to be in this trust? As I said before, it needs to have a spendthrift provision. The child with a disability, the beneficiary, needs to not be able to anticipate future distributions, not be able to assign them, but it needs to go further. A well-drafted third-party special needs trust should avoid the use of support or maintenance or any terms along similar lines, because we don't want to create any obligation of the trustee to make distributions. And here's what the line of cases assessing that says. They're not universal, by the way. These are state cases, primarily in a couple of states that have been particularly difficult on third-party special needs trusts. The argument is, look, if the trustee of a trust has the ability to make distributions for support, and has complete discretion, and the language of the trust says they can do anything they want, their discretion cannot be second-guessed, they still have to exercise that discretion reasonably. And it would be unreasonable to deprive the beneficiary of the trust of the support that would be available through the trust. And we don't really have to test the question of whether the trustee could sue and compel a distribution. The question is actually a different question. Can the Public Benefits Agency treat that trust as an available resource? And in at least 2 states, the courts have said yes. The Public Benefits Agency can, if the trust is for the support of the beneficiary, even if there is clear language that intended to give the trustee broad discretion. So a far better solution is to simply avoid the use of support or maintenance in the language of the trust. Is it fatal if it's in there? Will the trust fail? Not necessarily. In some states, they have not paid any attention to that kind of language. Over time, I think we can reasonably expect that more states will begin to pay attention to that language. So it's a good thing to not include in a third-party special needs trust. Another thing about the third-party special needs trust is they can have money from a lot of different sources. In fact, that's one of the selling points of a third-party special needs trust. Hey, Robert, create a special needs trust for your child with a disability, and your mother and your father and your mother-in-law and father-in-law and your other children and anybody else who wants to can contribute money to that trust because they're so concerned about your child. That's a common way of setting up a special needs trust, for a third-party special needs trust for a particularly young beneficiary who has a large extended family. And in fact, it's often done by the grandparents. Grandparents pay the lawyer to prepare the special needs trust, and then the parents' estate planning just got quite a bit easier. They can simply leave a share of their estate to the trust that has already been established without having to pay to establish a whole new third-party special needs trust. Third-party special needs trusts, as I said, they're the watermelons. They're wonderfully useful for all sorts of things in almost every state. They can be used to pay for therapy or medical care that's not covered by Medicaid, including non-traditional care, including barometric care or herbal care or anything that the family wants to give a shot because it might help, even though there might not be good evidence to indicate it. It's not going to be available through the Medicaid provider, but it can be paid for through a third-party special needs trust. Transportation and travel, vacations. Third-party special needs trusts are often used for vacation money so that the child with a disability can go to Disneyland or Disney World or theme parks. And by the way, if they require an aide to be along, one person can be paid as an aide to go with them. You can't send the whole family on third-party special needs trust money probably, unless the trust specifically provides that you can. But certainly you could pay for one aide, and that would be for the benefit of the child with a disability. Educational expenses, including special schools, camps, other kinds of adaptive equipment that allows a child to get into the educational system that they wouldn't be able to otherwise. Equipment, computers, other kinds of adaptive devices for mobility or the ability to drive or whatever might be out there that might not be covered by the public benefit system or might take too long to get funded through the benefits system. So the special needs trust can pay for something that Medicaid would otherwise pay for, but you can get it today rather than in a year or 2 years if it has to go through the Medicaid process. Companions, either for caretaking or for just socialization, to take a beneficiary to the movies, to go out on outings, to test their physical limits, to sign them up for rocks and ropes courses, or whatever it is that might make the beneficiary's life better, happier, more fulfilling. Entertainment. The movies themselves can be paid for out of the special needs trust. Case management, a very useful item that can be paid out of a special needs trust. Does the third-party special needs trust have to list all of those things? No. But my advice is it's a good thing to list these and others that come to mind to make it clear to the trustee that these are the kinds of things that this trust was intended to cover, and it can be used for all of them. Now let's talk about self-settled special needs trusts. With no longer new, but in 1993 when Congress passed a series of changes to the Medicaid law, along with all of the broad sweeping changes was one small section of the Medicaid code that came in that has a real effect on special needs trusts. It's codified at 42 USC section 1396 PD4. And it consists of 3 different sections. The D4A trust is what we generally think of as a self-settled special needs trust. And what that section of the code says, of the Medicaid code says, is that if a trust is established pursuant to this provision and money of a beneficiary is transferred to the trust, then the transfer is not a disqualifying transfer, and the assets in the trust will not be counted as available resources. The income to the trust will not be counted as income available to the beneficiary. So in other words, express permission for a Medicaid recipient or later an SSI recipient to transfer money to a trust under this section and not be disqualified from continuing benefits. Any other transfer of money into a trust will be disqualifying. So unless you satisfy the provisions of 1396 PD4, any transfer into a trust, whether it's done by a court or a lawyer for, or an insurance company for the benefit of, or a family member or anyone else, will be a disqualifying transfer. So all self-settled special needs trusts are going to have to look to 1396 PD4 and particularly D4A in order to determine whether they're valid trusts, self-settled special needs trusts. And this is part of the pomegranate problem. The first step of becoming a pomegranate is the ways in which the trust can be established and the kind of provisions are sharply limited. First limitation is that the trust has to be established by a parent, grandparent, guardian, or a court. So we just knocked out the insurance company or the lawyer establishing this trust. It can only be established by one of those people. And note what's not on that list. A competent beneficiary cannot establish his or her own 1396 PD4A trust. It has to be parent, grandparent, guardian, or court. In the real world, practically speaking, almost all of them are established by court action. The clear second place winner is by a guardian. Parents and grandparents often establish them, but it can be a challenging proposition to have the parent or grandparent both establish the trust and have the authority to fund the trust with the beneficiary's funds. The other big requirement of 1396 PD4A is the trust has to have a payback provision. It has to say that on the death of the beneficiary, all of the Medicaid payments that have been made for the benefit of that beneficiary by the state have to be reimbursed before the trust can be used for anything else. Now, in practical terms, that does not mean that the trust can't pay its taxes, that the trust can't pay its administrative expenses, but it does mean that the trust can't pay the family members for care, although there are a couple of cases in which that has been allowed. Those cases have been tamped down pretty strongly, and you simply cannot rely on the ability to pay for care that had already been provided at the time of the beneficiary's death. Cannot pay for burial and funeral arrangements, which doesn't stop the trust from prepaying burial and funeral arrangements, but on the death of the beneficiary, you can't pay for burial and funeral arrangements, unless, of course, there's enough money to pay back the entire Medicaid claim, and then also pay additional things that the trust can provide for. The trust can have provisions about what happens if there's more money in there. But few of these trusts have significant money left after the payback requirement is satisfied. That same section, 1396 PD4, has two other sections that we can talk about in dealing with other kinds of special needs trusts. One of them, D4C, is the pooled trust provision. And that section says that a transfer into an appropriately constructed pooled trust will not be a disqualifying transfer, and the money in that pooled trust will not be treated as an available resource, just as the D4A requirements. The D4C requirements do not impose the requirement that parents, grandparents, courts, or guardians be the settlers or establishers of the trust. It also has another interesting provision. It says that a pooled trust has to have a payback provision to the extent that the money is not retained by the trustee of the trust. And the trustee of the trust has to be a nonprofit entity. So the idea of a pooled trust is that some nonprofit, presumably charitable, but it doesn't say charitable, it says nonprofit. Some nonprofit sets up a trust to handle the funds of multiple beneficiaries and then provides that on the death of each beneficiary, the money stays in the trust for the benefit of the other beneficiaries, rather than going back to the state. If that's not what the trust says, then the state payback provision has to look just like the payback requirement in the D4A trust. Typically, because of the pooled nature of the trust, D4C trusts are used for smaller amounts. Trusts that are not large enough to justify the administrative expenses might be pooled together into a single, sometimes very large, pooled trust operated by a nonprofit. Often, but not always, the nonprofit is an affinity group. So the nonprofit might be something that deals with citizens with developmental disabilities, and most of the trust beneficiaries would be beneficiaries who have developmental disabilities. It's not required by the terms, but it's a pretty common arrangement. Generally speaking, pooled trusts are self-settled. That is to say, for tax purposes and for calculating the self-settled third-party distinctions, the trust is established to the extent of the contribution by an individual beneficiary. The trust is established by that beneficiary or by the beneficiary's guardian or agent or family member or whatever, but for their benefit. But it is possible to have a pooled trust that is a third-party trust, and a few of those have cropped up around the country as well. And then there's the Miller Trust, and I don't want to spend a lot of energy on this. First distinction is that it's only important in states which have adopted an income cap for Medicaid eligibility, usually long-term care Medicaid eligibility. About half of the states say that you can be denied eligibility for assistance with your nursing home care if your income is over a threshold. And the problem is that the threshold is below the cost of nursing care in almost all of those states. So what are we going to do with people who have no resources? They've used up all of their savings, and they have income insufficient to pay the nursing home bill, but they can't qualify for Medicaid. Well, that same enactment by Congress required states to allow the creation of an income trust that would just handle the income of beneficiaries who are over the state income cap, but not able to pay for their long-term care directly. Because the case that gave rise to this provision was called the Miller case out of Colorado, Miller versus Ibotta, they are fondly referred to as Miller trusts all over the country. And as I say, only about half of the states even care about them. They only work to solve income cap problems. They only work to solve the eligibility side of the problem. Once you become eligible for nursing home care, you have a requirement that you contribute most or all of your income to the facility to assist paying for your care. The Miller Trust allows you to become eligible, but it does not allow you to reduce the share of cost calculation. And so this kind of trust is only important in the half of the states that have income caps. It only deals with the income side of eligibility. It has nothing to do with the asset side. It only deals with the eligibility, not with the share of cost. Very limited significance, but in those states that have income caps, it's vitally important to understand the use of the Miller Trust. It's an easy tool for getting someone who would otherwise be ineligible for Medicaid onto a state program providing long-term care. And I told you earlier that I would revisit the sole benefit trust, so here's the sole benefit issue. 42 U.S.C. 1396 P. C2B sections little I 3 and 4 provide that transfers made by a Medicaid applicant to or to a trust for the sole benefit of a disabled child or other person will not be disqualifying transfers. In that simple sentence has been read a tremendous amount of information. So if I want to become eligible for Medicaid, but I have too much in resources, I could simply give all of my money to my disabled child, and I can then qualify. But my child is himself on public benefits, so if I give all my money to him, he will lose his public benefits. So couldn't I create a trust to manage the money, keep him on public benefits, and still qualify myself? And the answer is yes, I can, but that trust has to be for the sole benefit of my child with a disability. Subsequent interpretations have decided that I have to have that trust annuitized. We have to have figured out a way to reduce the trust to zero value, at least actuarially speaking, on the day of death of my child with a disability. Or I need to have a payback provision to pay back for his Medicaid care, just as if this were a D4A trust. So that trust looks to him very much like a D4A trust if I put that provision in. To me, it looks like a third-party trust because I was giving away the money in order for me to become eligible. From his side of the equation, he's receiving money and would like to stay eligible. So it's kind of a hybrid between the two. You often hear about the actuarial soundness of the trust, and that's that provision that says that the trust has to be constructed so that it would run out of money actuarially on the date of my child's death, or have a payback provision, which is treated as the equivalent of actuarial soundness. So what does all that mean? We can figure out that there are several principles that we can extract from all of that conversation about special needs trust. An executive summary, if you will. First one, every parent of a child with special needs needs to establish a third-party trust. Unless they truly have no assets to leave to the child, even small bequests, even life insurance beneficiary designations, even retirement accounts can mess up the child's public benefits eligibility and end up being difficult to manage, can require a guardianship of the estate or a conservatorship for a child with a disability if they're not able to handle their own funds. They can be an administrative nightmare. They can cause an interruption of benefits. It may be that there are no private options available. So even though there was plenty of money to pay privately, maybe the only care, maybe the best care is available from the public benefit system. Simply stated, every parent of a child with disabilities needs to have created a third-party special needs trust as part of their estate plan. Second principle we can extract, self-settled trusts can be very useful tools, but the cost and limitation mandate that we spend some energy trying to come up with alternatives first. Is it possible to spend down the money from a personal injury settlement or an unrestricted inheritance? Is it possible to purchase some things that will improve the quality of life and use up the money so that we don't have the continuing administrative burden of paying to administer the trust and the payback provision that's required at the end? Can the person disclaim? Well, probably not. Disclaimer is treated as a transfer for public benefits purposes, even though it's not a transfer for most other purposes, for tax purposes or for asset protection purposes. For public benefits purposes, a disclaimer is treated as a transfer. So can we come up with some other alternatives for the use of the money before we resort to a self-settled special needs trust? If not, the self-settled special needs trust will improve the quality of the beneficiary's life, but there are costs and downsides to the establishment of a special needs trust. State variations are substantial. I've hinted at a couple of individual state cases, regulations, or laws. There is tremendous variation among the states about how they deal with special needs trusts. One state presently is trying very hard to disqualify all special needs trusts, including third-party special needs trusts. It has mandated additional requirements that cannot be satisfied in most cases without a follow-up court hearing in order to discourage the use of special needs trusts. Other states have statutes that expressly permit the creation of special needs trusts and encourage them as supplements to the care that is provided through state Medicaid and other programs. So there's a tremendous amount of special needs trust variation, and because we have a highly mobile society, that means that you need to have flexibility built into every special needs trust to make appropriate amendments as a beneficiary and his or her family move from state to state or otherwise change their circumstances. Maybe the states will become more or less restrictive over time. Fourth basic principle, you need to understand what a Miller Trust is, and particularly if you live in an income cap state, you need to know if you are an income cap state. But once you have learned what a Miller Trust is and know your income cap status, you are done with Miller Trusts. They have such limited utility that they're only important for long-term care in those states that are income cap states. They can be tremendously helpful in those narrow circumstances. And the last executive summary bullet point that I want to highlight is that pooled trusts can be a low-cost alternative to other kinds of special needs trust planning, both third-party and self-settled planning. As I said before, in a lot of communities there are third-party pooled trusts now that might be a way to handle small estates. That's it. That's what I wanted to tell you about the basics of special needs trusts. I hope you got something out of it and enjoyed it.